Labor relations is the practice of managing and maintaining relationships with employees organized by labor unions, including the establishment, negotiation, and administration of collective bargaining agreements. President Franklin D. Roosevelt signed the National Labor Relations Act on July 5, 1935. In the private sector, labor relations, including relations with unions, is principally governed by the National Labor Relations Act, or NLRA. The NLRA covers virtually all private sector employers. The National Labor Relations Act, NLRA, is the body of federal law that principally governs the rights of workers to unionize. Under Section 7 of the Act, American workers clearly have the right to self-organization, which includes the right to form or be part of labor organizations. Workers have the right to bargain collectively through representatives of their own choosing, and to engage in other activities of a concerned nature for the purpose of collective bargaining, or for their mutual aid or protection. The NLRA protects the rights of workers to join labor unions that will best represent their interests and take action to defend their rights in the workplace. The National Labor Relations Board, or NLRB, is an independent agency of the United States government charged with conducting elections for labor union representation and with investigating and remedying unfair labor practices. The NLRA defines unfair labor practices to include interfering, restraining, or coercing workers, dominating or seeking to control the union, discriminating against workers for union activity, discharging a worker for union activity, or refusal to bargain in good faith. The Labor Relations Act of 1947, better known as the Taft-Hartley Act, was enacted June 23, 1947. The act, still effective, became law by overcoming U.S. President Harry S. Truman's veto on June 23, 1947. The Taft-Hartley Act restricts labor unions, making the following union activities illegal: coercing people to become members, using threats, intimidation, or violence, forcing an employer to punish a worker for not being a union player, charging excessive union dues, and refusing to bargain in good faith with the employer. The basic duties of an employer in trying to reach a collective bargaining agreement include meeting and conferring with union representatives on a collective bargaining agreement, bargaining in good faith, and agreeing to cover specific subjects as are required by the NLRA. Negotiations between an employer, typically represented by management, and a group of employees, usually represented by a union, regarding the terms and conditions of employment include mandatory provisions such as wages, work conditions, hours, holidays, vacations, sick leave, fringe benefits, grievance procedures, arbitration, health and safety, non-discrimination, no strike, no lockout, term and termination, management rights, discipline and discharge, seniority, union security, and remedies. Collective bargaining agreements are documents that cover terms and conditions of employment, as we just discussed. Example copies of such agreements are available on the Internet, as well as from any number of sources, including government agencies, commercial providers, and libraries. An employer should be familiar with what's typically contained in one of these agreements before ever sitting down at the bargaining table.